Thank you, Tilak sir. It's a very important question. How do judges decide? Is a very important question of judicial process.
So,
Um, and the rules of interpretation, including the golden rule of interpretation that you just referred, they have been evolved to ascertain and guide judges in the decision making process. So it's not just the golden rule of interpretation. There are three main rules of interpretation: the literal rule of interpretation, golden rule of interpretation, and the mischief rule of interpretation. However, as you just asked in the question, whether it is the ideology or personal orientation of the judge, personal experience of the judge, which comes into play during the decision making process, particularly when interpretation is being made, I would totally agree there. Yes, almost in all cases of interpretation, you have the personal subjective orientation of judges coming into play. Huh. So, and these rules of interpretation that we have, the literal rule, the golden rule, and the mischief rule. Literal rule says that judges have to give the literal meaning to the words, phrases, and expressions used in the law, which means basically the dictionary meaning or the grammatical meaning should be given effect. Golden rule says that when there is some absurdity or hardship created by the literal rule, then you can modify, judges can modify the meaning to a certain extent and adopt an interpretation which is more reasonable. And mischief rule seeks to give meaning from the point of view of the intention of the lawmakers, and tries to find out what is the purpose for which law was made, what is the mischief which is sought to be removed by the law, and then interpret. However, the current theory, contemporary theories of judicial process, how judges interpret, what factors, what considerations operate in the mind of the judges when they deliver their judgment. So contemporary theories are of one view. The realist school of thought is very clear that judges do bring their ideology, bring their experiences, their subjective preference for one norm over another norm, what they consider to be right or wrong. So they take the decision on the basis of a lot of subjective considerations, and all these rules of interpretations, precedents, provisions of the law, they are brought into support that decision which they have already taken on the basis of their subjective understanding of the provision. So I don't give too much weightage or too much importance to these. I don't think much importance should be given to the rules of interpretation in particular. The realist school of thought, which explains the judicial process, how the mind of the judges actually works. So if they come from a particular social class, they come from a particular experiential background, whether it is individual experience or the class experience or the society they have been moving into, that always plays a very decisive role when judges interpret the provisions of law. So much so, let me just give you one very old and very critical judgment of the US Supreme Court. US Supreme Court back in 1860s in Dred Scott versus Sanford gave a judgment that in the eyes of US Constitution, and this was Supreme Court of US, full bench of the Supreme Court, US Supreme Court, it gave a judgment that, and all those judges were white judges. The question was whether blacks under the US Constitution have had any rights, whether the US Constitution granted any rights to black people. And this Supreme Court bench, full bench of the US Supreme Court, came up with a judgment which said that in the eyes of the US Constitution, in the eyes of the makers of the US Constitution, uh, blacks were not even a human being, they were not even a person. Therefore, they could not be a citizen and they could not enjoy any right. And they were using the provision of the law, they were using the rules of interpretation to take such a drastic position about the position of blacks within the US Constitution. And later on we know that it led to a civil war in US, and eventually slavery was abolished and constitution was amended. So the personal identity, social identity, individual experiences, ideological orientations, they all come into play. And all these rules, precedents, provisions of the law, they are only brought in support of the position which is already determined, which is already determined sociologically, culturally, psychologically, politically determined positions. So therefore, I would suggest that judicial interpretation and the judicial process is not to be understood in the simple terms that, there are rules and you judges only pick one rule over the other. They don't do it. It is
Okay.
Professor Carl Levlin, whether it is Justice Cardozo or Justice Holmes. The realist school of law, I think, is the most relevant, it gives us the most accurate description of the reality, and we should try to understand judicial behavior and the judicial process from the realist school of law. And from that point of view, ideological orientation, as you asked in the question, is very, very important rather than the rules of interpretation. As far as the confusion created by judgments is concerned, I am of the opinion that this confusion which has been created by the judgments of Supreme Court is not accidental. It is deliberate and it is purposive, so that the the context, the excuse of confusion can be used to subvert and destroy reservation policies. This has been the history of the Supreme Court from the very beginning. It is not something new which we are experiencing only now. If you take up the very first important judgment decided by the Supreme Court on the reservation policy, it was in the state of Madras. We know that a policy was formulated. There were some policies of reservation which were in existence even before the commencement of the constitution, but after the commencement of the constitution, it was state of Madras which made a provision for proportional representation of all communities in educational institutions. State of Madras versus Champakam Durai Rajan. So first the High Court and the Supreme Court both struck it down on the ground, and the ground is very. I mean, today it is. If you go back and read the judgment, is that because the policy, although the policy provided proportional representation to all communities at that time, including Brahmins. But the Supreme Court was of the opinion that because this reservation policy, which is proportional reservation for different communities, does not keep 100% of the seats open for the Brahmins to be occupied. Therefore, it is unconstitutional. It is in violation of Article 29(2). It is in violation of Article 15(1), etc. That was the beginning. That was a judgment in 1951 itself. All Supreme Court upper caste judges, Brahmin judges. So that was the beginning when the Supreme Court started, in a way, derailing or curtailing the scope of affirmative action, which was inaugurated by the commencement of the Constitution. In fact, even the policies which were in existence before the commencement of the Constitution, they were also now threatened by the interpretative powers of the High Courts and the Supreme Court that they had acquired under the Constitution. And thereafter, so in sequentially, you asked me to discuss some leading judgments. Another important judgment is M.R. Balaji versus State of Mysore, which was delivered in 1962. This was a very important judgment, very problematic judgment, where the Supreme Court used its power to interpret the Constitution in order to impose some very, very serious limitations on the reservation policy. First of all, it mooted the idea that the reservation should not be on the beneficiaries of reservation socially and educationally backward classes, including scheduled castes and scheduled tribes, should not be identified on the basis of caste. Rather, economic criteria should be brought into existence. That was the kind of justification Supreme Court built in M.R. Balaji judgment. It also said, and very curious, and this point is very important for all of us, when the Supreme Court in M.R. Balaji was saying that, well, caste is not that important a criteria, we should take up economic criteria. One of the arguments that they gave was that caste is not a common phenomena of all communities. So it is only in the Hindu community that you find caste, but the Christian community and the Muslim community, there is no caste phenomena. Therefore, caste cannot be a common indicator for identification of socially and educationally backward classes. We know that it is a complete lie. Caste is as much a factor, as much the material reality among Muslims and Christians in every religious community. In the subcontinent, it is the caste which is the law, which decides the distribution of economic, social, political resources. So that was one second thing which the Supreme Court did in M.R. Balaji. Then it also went on to say that whenever there is a reservation provided, it is an exception to the equality clause. So basically, where affirmative action policy do not increase equality in the view of that Supreme Court in MR Balaji, but they decrease equality. That was the misunderstanding, not, and that is not misunderstanding. I say deliberate understanding of the Supreme Court. So that limited the scope of affirmative action policy. It laid down the foundation for, if reservation was an exception, the natural consequence was that it has to be less than 50%. So the foundation for 50% ceiling was laid down by the Supreme Court in MR Balaji judgment. And then they also brought into misinterpreted Article 335, which basically says that the state must take into account the claims of socially educationally backward classes, including scheduled caste and scheduled tribe, in making appointment in the state policies, so as to improve the efficiency of the administration. So the thrust of Article 335 is that if there is a affirmative action, if there is reservation for SC, ST and OBCs, then the reservation will improve the efficiency of administration. Supreme Court in MR Balaji totally misinterpreted it and said, well, if there is reservation, then the administrative efficiency might be compromised. So you see, all these problematic themes were laid down by the Supreme Court in MR Balaji versus state of Mysore. So then this MR Balaji judgment became a very favorite judgment of the judges of Supreme Court. After MR Balaji, which was delivered in 1962, for almost next 10 years, every judgment of the Supreme Court on the question of affirmative action reservation, they started quoting Balaji judgment. They started repeating 50% rule, although 50% rule was not there in MR Balaji. It was only a ratio. If you strictly go by the principle of ascertaining what is the binding force part of a judgment, because in MR Balaji the question of 50% ceiling was not an issue. Therefore, the observation of the Supreme Court in Balaji were in the nature of obiter dicta, which is not binding. If the judges of the Supreme Court make some irrelevant observations or passing observations, it was a 50% ceiling was a irrelevant observation. It was not an issue. It was an obiter dicta. It was a passing observation by the judges. But it was repeated in case after case after case. In fact, in T. Devdasan versus Union of India, 1 year after MR Balaji, this 50% rule and reservation as an exceptional device was used to destroy the carry forward rule. In Devdasan judgment, Supreme Court destroyed carry forward rule, which means that if this year some reserve vacancies were not fulfilled, then they could not be carried forward next year. So MR Balaji judgment was used by the Supreme Court to destroy carry forward rule, which was there. Similarly, MR Balaji was used by the Supreme Court to continuously hammer the point that caste should not be used as a criteria to identify socially and educationally backward classes. Again and again, this point was sought to be repeated by the Supreme Court, so that the caste order does not come to determine the affirmative action policies of the state. Then we eventually, after a long gap of some 10 years, we find that in 10-15 years, in fact, in 1976, we find that there is a judgment by the Supreme Court, State of Kerala versus N.M. Thomas, whereby for the first time Supreme Court realized that, say, if A has got 100 acres of land and B has got 0, taking 10 acres of land from A and giving it to B is not violation of equality. You have increased equality if you have taken some land from A and you have given it to B. Or if A has got 5 generations of educational capital and B has never seen the face of a college, school or university, then bringing B into school, college is not violation of equality. It is basically expansion of equality. So it was in N.M. Thomas versus State of Kerala versus N.M. Thomas in 1976, that Supreme Court for the first time recognized that affirmative action policies and reservation policies, they do not violate equality. they increase equality. So now finally, after 25 years of the Constitution, Supreme Court said, "Achha, now we have understood what is equality, and it is not an exception. Article 15.4 or Article 16.4 is not an exception to Article 15.1 or 16.1. Rather, it is part and parcel of equality. When the state makes affirmative action policies or grants reservation in educational institution or public services, that increases social equality. That does not decrease social equality. However, despite making this change of heart on the principle of equality, Supreme Court did not in any way touch the 50% ceiling, because the natural consequence of this change in the position of the Supreme Court was, now because reservation or affirmative action is not an exception, it is rather a norm, to use the word of the Supreme Court, emphatic assertion of the principle of equality, then 50% ceiling could not remain. That ceiling should have gone then and there. Still, the Supreme Court, after N.M. Thomas judgment, also persisted with the 50% ceiling. And in N.M. Thomas, there was a discussion about the creamy layer aspect, principle of creamy layer. Instead of removing 50% ceiling, what happened was creamy layer was later on imposed. It was again a device when this N.M. Thomas judgment is celebrated as a judgment where there was a fundamental transformation. Some scholars of constitutional law try to present N.M. Thomas judgment as a transformative judgment. But there is no real transformation. There was only lip service was paid that, okay, reservation is not an exception, rather it is a norm. But in practice, what the Supreme Court did in N.M. Thomas was to lay the foundation of creamy layer principle, which is not there in the text of Article 15 or 16. Similarly, it did nothing to destroy the 50% ceiling. And therefore, as a result of which, when in Indira Sahni judgment, these questions came up, Supreme Court once again in Indira Sahni judgment ended up maintaining 50% ceiling. 9 judges bench of the Supreme Court now said, well, there has to be 50% ceiling. They also imposed creamy layer on OBC. That creamy layer has to be excluded before OBC reservation could be granted. They destroyed reservation in promotion in Indira Sahni, said, well, no reservation in promotion. Indira Sahni destroyed carry forward rule. So many problems. They were over the period of time. If you map the journey of the Supreme Court on affirmative action policies, what we find is, in Indira Sahni, Supreme Court also said no reservation for super speciality or high technical post. So number of problems were created and conditions were imposed by Indira Sahni judgment, while approving, paying lip service to this equality principle, and also validating 27% OBC reservation. Number of conditions were imposed. Constitutional amendments were made. Now look at the constitutional amendments were made to do away with the problems created by Indira Sahni judgment. In Article 16, number of amendments took place. Constitution 77th Amendment, Constitution 85th Amendment, they were all added to do away with the problems created by Indira Sahni judgment. However, when these amendments were challenged, the constitutional validity of these amendments were challenged in M. Nagaraj versus Union of India in 2006. Now again, Supreme Court totally misinterpreted Indira Sahni judgment. 5 judges bench now. Indira Sahni was 9 judges bench. 5 judge bench could not overrule Indira Sahni, 9 judges. But in M. Nagaraj, Supreme Court said, well, 3 conditions will have to be fulfilled before granting reservation, which is, first of all, show that there is backwardness of that class. Data should be collected. The state must collect data to show the backwardness of a class. Then it should show the data should be collected to show that the class is not adequately represented in the services. And third condition was imposed, that it should not dilute the efficiency as understood by the Supreme Court and read under Article 335. I have said that it was originally misread in M.R. Balaji judgment. So M. Nagaraj judgment went out to impose conditions. Also made suggestion that it could be creamy layer now could be imposed on scheduled caste, scheduled tribe also, when Indira Sahni judgment had clearly said that it is only dealing with OBC reservation policy, and scheduled caste, scheduled tribe is not an issue. Misinterpreted M. Nagaraj and made that suggestion. Now, after M. Nagaraj, After M. Nagaraj, Jarnail Singh judgment was delivered. Jarnail Singh versus Lakshmi Narayan Gupta in 2018 to explain the meaning of M. Nagaraj. Now, while explaining the meaning of M. Nagaraj, Supreme Court did say, okay, well, the data collection and all that is not necessary in cases of scheduled caste and scheduled tribe. But it again made an observation that creamy layer has to be imposed on scheduled caste and scheduled tribe. So you see the strategy. No, it is not a mistake. It is not an error. BK Pavitra 2 in 2019, which has been sometimes presented as a very progressive judgment, but if you read BK Pavitra 2, where reservation in promotion for scheduled caste and scheduled tribe was finally, in the context of Karnataka, was upheld, it goes on to support creamy layer principle. It goes on to support 50% ceiling. So what happened? What has been happening in the garb of interpreting the provision of the Constitution? Supreme Court judges who almost exclusively come from upper class background, they have been imposing hurdles after hurdles. They have been digging trenches after trenches so that the affirmative action, whatever little affirmative action has been taken by the state, it does not lead to any positive results. In fact, what has happened over the period of time, what we see is that derailment of social democracy, derailment of social justice by the judges of Supreme Court, by the judges of High Courts. This has been happening from 1951, after the coming into existence, commencement of the Constitution and creation of Supreme Court, till date. So you see the absurdity of the rule. If the state wants to give reservation, Supreme Court will say, well, give us data. This data, that data, X, Y, Z data. But if the state wants to abolish reservation, say in the case of Uttarakhand and a number of other states we have seen, then Supreme Court cannot do, or High Court cannot do anything. When reservation is granted, then you will say data collection is necessary. But when reservation is abolished, then you don't insist that data collection is necessary. How can you unilaterally abolish? Similarly, when Article 15(1), 16(1), yeah, sir, is just last point. When it is already 15(1), 16(1), reservation is part of 15(1), 16(1), which is fundamental right, which is enforceable under Article 32, 226. How can the Supreme Court keep on saying that these provisions are only enabling provisions? There is no fundamental. This is a fundamental right. It is part of Article 16. It is part of Article 15. It is part of Article 14. How can the Supreme Court say that it is not a fundamental right and it will not issue a writ for the enforcement of reservation policy? It is basically because the Supreme Court itself is casteist. It consists of upper caste judges exclusively. High courts also are similar in nature, and it is for the Supreme Court to reflect whether they have loyalty to the constitutional ideals of liberty, equality, and fraternity. They will have to reflect. Otherwise, their judgments are all clear, like the judgment of the US Supreme Court in Dred Scott versus Stanford, that blacks are not even persons, they are not human beings, they are not citizens. And it led to civil war in US. These kind of misinterpretation by the judges of the Supreme Court and High Court, they are leading to very serious problems. When social democracy is destroyed, the constitutional democracy also becomes at risk. It's very simple. If honest, fair, impartial judgments are to be delivered by the Supreme Court and High Court, then they have to be representative of different social classes. So scheduled caste, scheduled tribe, other backward classes. Also, the horizontal representation of women in higher judiciary has to be there. Without proportionate representation of different social classes in high courts and the Supreme Court, it is impossible. It is impossible. It is unrealistic. It is foolish to expect that fair, impartial, and just decisions on questions of social justice will come from High Courts and Supreme Court. And I think that for that purpose, even the communities will have to make now Supreme Courts have made it. Supreme Court and High Courts have made it very clear. Communities will have to make their own efforts. Will have to take the legal education as a movement, as a big time movement, and first fill the bar as much as possible and occupy all the important position in the bar, and eventually force the bench. When I force the bench to accommodate the legitimate and constitutional claims of SC, ST, and OBC communities in the matters of appointment of judges of High Court and Supreme Court. That's the only way to get some fair, impartial, just judgments from the High Courts and Supreme Court on the questions of social democracy. In conclusion, I would say that the power to interpret the Constitution is a very important power, and this power cannot be left in the hands of a very small segment of the society. If we as a society, as a civilization, as a country are to realize the ideals of the Constitution, which are enshrined in the preamble, then we have to find ways and means to make sure that every social class, particularly SC, ST, and OBC communities, are proportionately represented in every tier of the higher judiciary. And it is only through the proportional representation of all social classes that we can have constitutionally alive progressive interpretation by the judges of High Court and Supreme Court, without which even the basics of constitutional democracy, they get endangered, and it becomes very serious problem for the Constitution to uphold the rule of law, to advance the what is known as constitutional democracy in the form of representative democracy. Representative democracy, all those ideals, they go into dustbin. We have to therefore find ways and means to make sure that all social classes are proportionately represented in the High Courts, in the Supreme Court. Last point, that I have written an article on it, that the fight against only fighting collegium may not help the cause of Bahujan to get representation in High Court and Supreme Court. We'll have to basically root for amendment in the Constitution which directly guarantees representation, or amendment to the rules of the Supreme Court, or memorandum of procedure which is there for the appointment of judges of High Court. Amendment to the memorandum of procedure, that is far better effective way to make sure that Bahujan community, SC, ST, OBCs are represented in High Court and Supreme Court, rather than only fight. Mere fighting or abolishing collegium is not going to automatically increase the representation of SC, ST, and OBC Supreme Court or High Court. So that is the last point with which I would conclude. Thank you very much, Tilak sir, and thank you MNT News Network for giving this opportunity to express my views. Thank you.